Question 1. A California notary is asked to notarize a document that will be filed in another country. The document does not have a notarial certificate attached. What should the notary do? A. Refuse to perform the notarization. B. Attach a California Jurat certificate. C. Attach a California Acknowledgement certificate. D. Advise the signer on which certificate is appropriate and attach it. Answer: A. Refuse to perform the notarization. A notary must refuse to notarize if a document is incomplete, which includes the absence of required notarial certificate language. Notaries are prohibited from choosing the type of notarial act or certificate on behalf of a signer, as this would constitute the unauthorized practice of law. For example, if a client presents a document for a foreign real estate transaction without a certificate, the notary cannot decide whether an acknowledgement or a jurat is needed. Always remember, the signer or the receiving agency must provide the proper notarial wording. Your role is to complete it, not create it. Question 2. A notary public is required to keep their official notary seal and journal. A. In any location as long as it is locked. B. At their primary place of business during work hours. C. Under their direct and exclusive control at all times. D. With their employer if the employer paid for the commission. Answer: C. Under their direct and exclusive control at all times. The notary's official seal and journal are their personal tools of office and must always be kept under their direct and exclusive control. This rule prevents unauthorized use by others, which could lead to fraud and significant liability for the notary. Even if an employer pays for the notary's commission, the seal and journal belong to the notary and must not be left in a shared desk or an unlocked office. Think of your seal and journal like your driver's license or passport. They are your responsibility alone. Question 3. What is the maximum fee a California notary may charge for administering an oath for a deposition? A. $15 per signature. B. $30 for the entire deposition service. C. $7 for the oath, and $7 for the certificate. D. $10 per person. Answer: C. $7 for the oath, and $7 for the certificate. The maximum fee for administering an oath to a witness in a deposition is $7, and an additional fee of $7 may be charged for the certificate of the deposition. California law sets specific maximum fees for various notarial acts, and it is crucial to know these limits to avoid overcharging, which can result in penalties. For deposition services, the law breaks down the allowable charges, distinguishing the act of administering the oath from the act of certifying it. It's a good tip to keep a copy of the authorized fee schedule at your desk for quick reference. Question 4. When a signer presents an unfamiliar document written in a foreign language for an acknowledgement, what must the notary do? A. Refuse to notarize the document. B. Require the signer to provide a certified translation of the document. C. Proceed with the notarization as long as the notarial certificate is in English. D. Have a trusted colleague translate the document's contents. Answer: C. Proceed with the notarization as long as the notarial certificate is in English. A notary is not responsible for the contents of the document they are notarizing. Their duty is to the notarial act itself. As long as the notary can communicate with the signer to properly identify them and complete the certificate, the notarization can proceed, provided the notarial certificate is in a language the notary understands, which is typically English. For instance, if someone brings a Spanish-language contract with a standard California acknowledgement certificate attached, the notary can perform the act without reading or understanding the contract. Your focus is on the signer and the certificate, not the document's substance. Question 5. A notary's commission term in California is for how many years? A. 2 years. B. 4 years. C. 5 years. D. 10 years. Answer: B. 4 years. A California Notary Public Commission is valid for a term of 4 years, beginning on the date specified in the commission. To continue serving as a notary, the individual must reapply and successfully pass the state exam before their current commission expires. There is no grace period, so if a commission expires, the notary must cease all notarial activities until a new commission is issued. A helpful way to stay prepared is to set a calendar reminder 6 months before your commission's expiration date to start the renewal process. Question 6. A notary changes their business address to a new county within California. What must the notary do? A. Resign their commission and reapply in the new county. B. File a new oath and bond in the new county of residence. C. Nothing, as the commission is valid statewide. D. Notify the Secretary of State of the address change within 30 days. Answer: D. Notify the Secretary of State of the address change within 30 days. A notary's commission is valid throughout the entire state of California, regardless of their county of residence or business. If a notary moves their business or residential address, they are only required to notify the Secretary of State in writing within 30 days of the change. They do not need to file a new oath or bond in the new county until they renew their commission. To remember this, think of your commission as a statewide license. You can move around freely, but you must keep your address updated with the licensing authority. Question. 7. A journal entry must be a full-line item made at the time of the notarization and include: A. The signer's occupation. B. A note on the signer's demeanor. C. The fee charged for the notarial act. D. The name of the person who referred the signer. Answer: C. The fee charged for the notarial act. California law requires that for every official act, a notary record the fee charged in their sequential journal. This entry is mandatory, along with other key details like the date, time, type of notarial act, document type, signer's signature, and method of identification. Omitting the fee, even if no fee was charged, in which case 0 or no fee should be written, makes the journal entry incomplete and non-compliant. Always make it a habit to fill out the fee column for every single notarization, as it is a required and auditable part of your record. Question 8. A notary is presented with a document that has already been signed. Which notarial act can the notary perform? A. Acknowledgement. B. Jurat. C. Proof of execution by subscribing witness. D. None of the above. Answer: A. Acknowledgement. An acknowledgement is a notarial act where the signer declares to the notary that they have already signed the document. The key purpose of an acknowledgement is to verify the identity of the signer and confirm that they signed willingly, not to witness the signing itself. For a jurat, the signer must sign the document in the notary's presence after taking an oath or affirmation. Therefore, if a document is pre-signed, only an acknowledgement is possible, provided the signer personally appears and acknowledges their signature. Question 9. In California, a notary can certify a copy of which of the following documents? A. A birth certificate. B. A power of attorney. C. A university diploma. D. A marriage license. Answer: B. A power of attorney. California notaries have very limited authority to certify copies of documents. They can only certify copies of a power of attorney or copies of their own notary journal entries if requested. For vital records like birth or marriage certificates, the official custodian of those records, e.g., the county recorder or Office of Vital Records, is the only entity authorized to issue certified copies. Trying to certify a copy of a birth certificate would be an unauthorized act. Remember this simple rule: unless it's a power of attorney or your journal, you can't certify a copy of it. Question 10. A subscribing witness is used to prove the execution of a document when the principal signer cannot appear before the notary. The subscribing witness must swear under oath that A. They know the notary personally. B. The principal signer is out of the country. C. they either saw the principal sign the document or heard the principal acknowledge their signature. D. They are named as a beneficiary in the document. Answer: C. They either saw the principal sign the document or heard the principal acknowledge their signature. The purpose of a proof of execution by a subscribing witness is to have a third party vouch for the principal's signature when the principal cannot be present. The subscribing witness must be put under oath and must state that they personally know the principal, and that they either watched the principal sign the document or that the principal told them the signature on the document was theirs. This act serves as an alternative to a direct personal appearance by the document's signer. This is a rare notarization, so always review the specific steps carefully if you are asked to perform one. Question 11. What does the venue on a notarial certificate indicate? A. The county where the signer resides. B. The state and county where the notarization is taking place. C. The location where the document will be filed. D. The state where the notary's commission is filed. Answer: B. The state and county where the notarization is taking place. The venue, written as State of California, County of _________________, establishes the geographical location where the notary and the signer are physically located at the time of the notarization. It is not necessarily the county where the notary lives or where the property is located, but specifically where the notarial act occurs. For example, if a notary commissioned in Los Angeles County performs a notarization for a signer while they are both in Orange County, the venue must state County of Orange. An easy way to remember this is, the venue is where you're at when you notarize. Question 12. A thumbprint is required in the notary's journal for any document affecting real property. Which of the following is an example of such a document? A. Power of attorney. B. Living will. C. Deed of trust. D. Car title. Answer: C. Deed of trust. California law mandates that a notary obtain the signer's thumbprint in the journal entry for any document affecting real property, such as a deed, quitclaim deed, or deed of trust. A power of attorney also requires a thumbprint, but a deed of trust is a clear example of a document that directly encumbers or transfers an interest in real property. Documents like wills or car titles do not fall into this category. The thumbprint requirement is a powerful anti-fraud measure for high-stakes real estate transactions. Question 13. How must a notary correct an error made in their official journal? A. Use correction fluid to cover the mistake and write over it. B. Erase the error and write the correct information in its place. C. Draw a single line through the error, write the correction, and add their initials. D. Tear the page out of the journal and start over. Answer: C. Draw a single line through the error, write the correction, and add their initials. A notary journal is a legal record, and any corrections must be made in a way that keeps the original entry legible. The proper procedure is to strike through the incorrect information with a single line, write the correct information nearby, and then initial and date the correction. Using correction fluid, erasing, or removing pages can be viewed as tampering with an official record. Think of it like correcting an entry in a financial ledger: you must show the change transparently, not hide the original mistake. Question 14. If a notary's official seal is lost, stolen, or damaged, the notary must: A. Order a new seal immediately and continue notarizing with it. B. Notify the Secretary of State immediately in writing. C. Wait until their commission is renewed to get a new seal. D. Post a notice in a local newspaper for 30 days. Answer: B. Notify the Secretary of State immediately in writing. The loss, misplacement, or theft of a notary seal is a serious security issue that must be reported to the Secretary of State without delay. The notification must be in writing, by certified or registered mail, so there is a record of the report, which protects the notary from liability if the seal is used fraudulently. After notifying the Secretary of State, the notary can then order a new seal. The first and most critical step is always immediate notification to the authorities. Question 15. The purpose of the $15,000 notary surety bond is to A. Provide a source of funds to reimburse members of the public who are harmed by notary misconduct. B. Pay for the notary's legal defense if they are sued. C. Cover the notary's personal financial losses due to an error. D. Act as a fee paid to the Secretary of State for the Notary Commission. Answer: A. Provide a source of funds to reimburse members of the public who are harmed by notary misconduct. The $15,000 surety bond is a protection for the public, not for the notary. If a notary's negligence or intentional misconduct causes financial harm to a member of the public, the injured party can file a claim against the bond to recover their losses, up to $15,000. It is not an insurance policy for the notary. In fact, if the bonding company pays out a claim, it will then seek reimbursement from the notary. A good way to remember this is that the bond protects them, the public, from you, while errors and omissions insurance protects you. Question 16. A single credible witness is used to identify a signer who does not have satisfactory identification. The credible witness must A. Sign the document being notarized. B. Be at least 16 years of age. C. Not have a financial interest in the document. D. Be personally known to the notary. Answer: D. Be personally known to the notary. When using one credible witness to identify a document signer, the law requires that the witness be someone the notary personally knows. The notary's personal knowledge of the witness provides the foundation of trust for the identification. The witness must also personally know the signer, take an oath, and sign the notary's journal, but the critical link for the one-witness method is the notary's prior relationship with that witness. If the notary doesn't personally know the witness, two credible witnesses, who do not need to be known by the notary but must present their own ID, are required. Question 17. Which of the following statements is true regarding a jurat? A. The signer may acknowledge that the signature on the document is their own. B. The signer does not need to be physically present if the notary knows their signature. C. The signer must sign the document in the notary's presence. D. The notary is certifying the identity of the signer and the legality of the document. Answer: C. The signer must sign the document in the notary's presence. The core requirements of a jurat are that the signer must personally appear before the notary, be put under an oath or affirmation, and sign the document in the notary's presence. The purpose of the jurat is for the signer to swear or affirm that the contents of the document are true, and the notary's presence during the signing confirms that it was indeed that person who signed. This differs from an acknowledgement, where the document can be signed beforehand. A good memory aid is: jurat sounds like jury, where you swear to the truth and sign in front of an official. Question 18. A notary who is also a licensed immigration consultant may not advertise their notary services in any language by A. Using the literal translation of notary public. B. Including their notary commission number in the advertisement. C. Stating the fees for notarial services. D. Using the phrase notario or notario publico. Answer: D. Using the phrase notario or notario publico. California law strictly prohibits any notary from using the terms notario, notario publico, or any similar phrase in advertising, as it is misleading. In many Latin American countries, a notario publico is a high-level attorney with extensive legal powers, and using this term in the U.S. can deceive immigrants into believing the notary can provide legal advice. This rule is in place to prevent the unauthorized practice of law and protect vulnerable consumers. Even a literal, non-misleading translation is restricted if it implies the notary has legal authority they don't possess. Question 19. If a private employer pays for an employee's notary commission and supplies, who owns the notary journal and seal? A. The employer, as they paid for the materials. B. The notary public. C. The employer, but only during business hours. D. the Secretary of State. Answer, B, the Notary Public. The Notary Commission, seal, and journal belong exclusively to the individual notary to whom the commission was issued, regardless of who paid for them. An employer cannot control or retain the notary's tools of office, even if the notarizations are performed as part of the employee's job duties. Upon termination of employment, the notary must take their seal and journals with them. Think of the commission as a personal professional license. It is non-transferable and remains with the individual. Question 20. A person requests a certified copy of a line item from a notary's journal. The notary must respond to the written request within A. 24 hours. B. 5 business days. C. 15 business days. D. 30 calendar days. Answer, C. 15 business days. Upon receiving a written request specifying the names of the parties, the type of document, and the month and year of the notarization, a notary must supply a photostatic copy of the corresponding journal line item within 15 business days. The notary can charge a fee of up to 30 cents per page for this copy. This requirement ensures that the public has timely access to these public records for legal or verification purposes. Remember, 15 business days, as the standard turnaround time for official journal requests. Question 21. A Signer's driver's license expired 15 days ago. Can the notary accept this ID to perform an acknowledgement? A. No, the ID must be current. B. Yes, as long as it was issued within the last 5 years. C. Yes, but only if the physical description is still accurate. D. No, unless the signer also provides a current credit card with a photo. Answer, B. Yes, as long as it was issued within the last 5 years. California law allows a notary to accept an identification card or driver's license issued by the California Department of Motor Vehicles as satisfactory evidence, even if it is expired, as long as it was issued within the last 5 years. The ID must still contain the required elements: a photograph, a physical description, a signature, and a serial number. This provision allows for situations where a person, such as an elderly individual, may have an otherwise valid ID that has recently expired. Always check the issue date, not just the expiration date, on an ID. Question 22. When a person who cannot write their name needs to execute a document, this is called a signature by mark. The mark must be witnessed by A. the notary and one other person. B. 2 witnesses, who must also sign their own names on the document. C. 1 credible witness known to the notary. D. the notary alone, who will note it in the journal. Answer, B. 2 witnesses, who must also sign their own names on the document. For a signature by mark to be valid, 2 witnesses are required in addition to the notary. 1 witness must write the person's name next to their mark, and the second witness must write their own name as a witness. The notary's role is to notarize the mark as if it were a signature, and the journal entry must include the signatures of the 2 witnesses. This 2-witness rule provides a strong safeguard to verify the identity and intent of a person who cannot sign for themselves. Question 23. A notary is asked to notarize a document for a family member. This is permitted as long as A. the notary has no direct financial or beneficial interest in the transaction. B. the family member is not immediate family, such as a spouse or child. C. no fee is charged for the service. D. the family member shows 2 forms of identification. Answer, A. the notary has no direct financial or beneficial interest in the transaction. California law does not prohibit notarizing for relatives, however, it strictly prohibits a notary from acting in any transaction where they have a direct financial or beneficial interest. This means a notary cannot notarize a document that names them, their spouse, or any other party in a way that provides them a direct benefit, such as being named a grantee on a deed or a beneficiary in a trust. For instance, notarizing a car title transfer for your sibling is fine, but notarizing a deed granting you ownership of your parents' house is prohibited. The key is to avoid any conflict of interest. Question 24. A notary who resigns, is disqualified, or has their commission revoked must deliver all notarial journals and papers to A. The Secretary of State's office in Sacramento. B. The local police department. C. The county clerk in the county where the notary's current oath is on file. D. A successor notary public. Answer: C. The county clerk in the county where the notary's current oath is on file. When a notary's commission ends for any reason other than death, they are legally required to surrender their notarial records and papers to the clerk of the county where their oath of office is on file. This ensures the permanent public availability of the records. The notary must destroy or deface their seal at this time. Forgetting to turn in the journal is a common error that can result in penalties, so always remember that your records must be officially archived with your county clerk upon leaving office. Question 25. Under what circumstances can a California notary refuse to provide notarial services? A. If the signer does not speak English. B. If the notary has a reasonable suspicion that the signer is being coerced or does not understand the document. C. If the signer is from a different country. D. If the document is overly complex and contains legal jargon. Answer: B. If the notary has a reasonable suspicion that the signer is being coerced or does not understand the document. While a notary cannot refuse service based on discriminatory reasons, they have a duty to refuse if they cannot be certain of the signer's identity or if they suspect fraud, duress, or a lack of understanding. A notary must ensure the signer is acting willingly and is aware of what they are signing. For example, if a signer appears confused, intimidated by another person in the room, or unable to communicate their intent clearly, the notary should stop the notarization. A core function of a notary is to serve as an impartial screen against fraud and protect vulnerable signers.